By the time Roe v. Wade came down, she'd actually already had the baby. So the reason the case continued was because there was a desire both by litigants and by the Supreme Court to address the issue, not because there was an individual pressing case that someone brought.
The first argument was in the winter of 1971, but 2 justices had suddenly died prior to that argument, so they were short on the bench. They have the oral argument in Roe. Shortly after, they have the oral argument in a case called Eisenstadt versus Baird, which was about extending the right to use contraception beyond married couples to single people. The right to privacy, as invented by the Supreme Court, is the absolute foundation for the modern jurisprudence on abortion.
Privacy is a bit of a lightning rod and had been a bit of a lightning rod because it is not clearly established in the Constitution.
In fact, there's no references to privacy of the sort that would remotely have to do with contraception or other public morals laws of that nature.
Substantive due process is not actually described in Roe. It's invoked. It's the underlying doctrine that gives us the right to privacy.
So the 14th Amendment has a due process clause, as does the 5th Amendment. The 5th Amendment applies to the federal government, the 14th to the states, and it says that no state shall deprive any person of life, liberty, or property without due process of law. And basically, substantive due process says that there are some rights that are sufficiently important that the legislature can't take them away arbitrarily without violating the due process clause.
Locational privacy is clearly in the text of the Constitution. And I think it's fair to say freedom of thought has a privacy element. Then we move to this decisional privacy, which is the right to make decisions without the government directing the outcome of the decision-making process. And then we get to the right to act on the decision regardless of the community's beliefs that that action is contrary to the public good or contrary to what we would call state interests.
The first opinion to suggest that there's a fundamental right to privacy was Griswold versus Connecticut, which was a 1965 case holding that married couples have a right to use contraception with a doctor's prescription, contrary to a Connecticut law that banned such contraceptive uses.
It's a violation of a right to privacy. It's a violation of substantive due process because this is the kind of intimate decision, no different from who you marry or whether you have children or how you raise your children, that should be given to the individual, and the state shouldn't be able to interfere with that.
Where did the court purport to find this right to marital privacy, which includes a right to contraceptives? Well, since the court couldn't find it in the text, the majority said that they found it in penumbras formed by emanations of various constitutional guarantees.
Unsurprisingly, what followed was a case that said, well, why should only married people have a right to access contraception? Single people should have that right as well. And that was Eisenstadt versus Baird.
Eisenstadt laid a far firmer foundation, at least rhetorically, for the court to sit on in Roe. Griswold versus Connecticut opinion had said that married couples have a right of privacy that inheres in marriage and that is in the marital bedroom. These are sacred places you don't interfere with as the state. Eisenstadt said, we're not going to use that penumbras and emanations of other elements of the Bill of Rights. There is a constitutional right for people to make decisions that are very, very important to them. We call this a right of privacy.
So what you have is a situation where what seemed to be a limited right to privacy in Griswold that only applied to marital relationships now applies to all relationships. And then the next step in Roe is to suggest that rather than only applying to contraceptives, it applies more generally to the right of whether you want to have children or not.
The court, having heard Eisenstadt in between the two arguments and having decided it, can now say, well, don't you see, we've just announced a substantive due process right of privacy about matters so fundamental as the right to decide whether to bear or beget a child. And gee, abortion is about the decision whether or not to bear or beget a child. Fits perfectly. There was a practical reason for the re-argument, but it ended up suiting the decision to invent a right to abortion to a T.
The arguments in favor of Roe v. Wade, which finally persuaded the justices, were that abortion is a purely private matter. And when matters are purely private, general constitutional principles forbid the government from intruding into them.
The state of Texas responded that, in fact, there was no basis in the Constitution itself for a right to abortion, that state governments had regulated abortion either through the common law crimes or at least beginning in 1832 through statutory crime, to suggest that the 14th Amendment included some sort of protection against prohibition of abortion simply disregarded the historical record.
Instead of making a relatively limited argument about the state's ability to regulate abortion, they said the states must regulate abortion, which no court in the United States, at least, has ever held to be the case. So that was kind of a surprising argument in retrospect.
So for Texas, it was really a states' rights issue, and it was also an issue about the obligation that we usually say the state has to protect people who can't protect themselves.
Roe versus Wade seems crafted to stoke the debate on abortion. Its analysis of the right of privacy is controversial in the first place. Is there such a thing as a right of privacy? Its extension of it to abortion. Roe said, we are not deciding questions about the value of life before birth. But it did.